husband and the wife had been living together for 10 years. During these 10 years of marriage, the husband has been physically abusing the wife. The husband would often come home drunk, abusing the wife. After physically hurting the wife, the husband would sleep. The following morning, the husband would ask forgiveness from the wife. He would give the wife gifts. The next day again, he would physically abuse the wife. The following morning, would again ask sorry and would again shower the wife with gifts. This had been the situation for 10 years. Until one night, the husband arrived home. The husband was again drunk. Upon seeing the wife, he repeatedly slapped the wife, punched the wife, boxed the wife, until the wife fell on the floor, and then the said husband went to the bedroom and fell asleep. The wife was staring at the husband. She was so afraid that the moment the husband would again be awakened, again, she would be physically injured. And she has this fear that the next time it would not only be her, but also their children. So upon seeing that the husband was there, lying on the bed, fast asleep, what the wife did, the wife went to the kitchen, took a knife, and stabbed the husband to death. The wife was now prosecuted for the crime of parricide. The wife invoked battered woman syndrome as a defense. And the wife presented the psychiatrist whom she had been consulting for years. And the psychiatrist said that indeed, this woman had been suffering from battered woman syndrome. What is the effect of such proof that at the time of the commission of the crime of parricide, that of killing her husband while fast asleep, she was under battered woman syndrome. She was at the time suffering from battered woman syndrome. It will exempt the said woman from both criminal and civil liability. Battered woman syndrome is a scientifically defined pattern of psychological symptoms found in women living in battering relationship as a result of cumulative abuse. Under Section 26 of RA 9262, the law provides that victim survivors who are found by the court to be suffering from battered woman syndrome do not incur any criminal liability nor civil liability, notwithstanding the absence of any of the elements of the justifying circumstance of self-defense. So even if at the time that the said wife killed and stabbed the husband was not making any unlawful aggression, even if none of the elements of self-defense is present, the fact that it was proven in court that at the time of the killing she was in the state of battered woman syndrome, her act will be considered as justified. She is exempted from both criminal and civil liability. Therefore, it is akin to a justifying circumstance under Article 11. No criminal, no civil liability. Under Section 26, however, the law provides that, under the second paragraph, that in order to determine the state of mind of this woman accused, there must be an expert testimony coming from psychiatrists and psychologists. And that happened in the case. The said defense presented the psychiatrist whom the said woman had been consulting. Therefore, no criminal and no civil liability. But what if the husband and the wife had been living for 5 years? These 5 years of marriage was good years of marriage, until on the 5th year the husband lost his job. And since the husband lost his job, he became irritable, jobless. At night, he would go out with friends and return home drunk. The said woman, the said wife, was the one working for the family. But every time the husband would return home drunk, he would verbally abuse the wife. He would call the wife names, scold the wife, verbally abusing the wife, to lower the moral of the said wife. This has been occurring for months since the said husband lost his job. One night, the husband arrived home, drunk. Upon seeing the wife, he did not only verbally abuse the wife, this time he hit the wife several times. After hitting the wife several times, the husband went to bed. The following morning, seeing the contusions and hematoma on the part of the wife, he asked forgiveness and promised he will not do it again. However, the said promise was only good for a few days. After a few days, the husband again would go out with his friends every night. And every time he returned, he would again verbally abuse the wife. One time, the husband arrived home, drunk. Upon seeing the wife, he again scolded the wife, saying foul words against the wife. Thereafter, he went to bed. The wife, looking at the husband, became so afraid that the moment the husband would be awakened, this time, the husband would not only verbally abuse her, but would again hit her. And so what the wife did, he took a knife and stabbed the husband to death. The wife was charged with the crime of parricide. The wife invoked battered woman syndrome under RA 9262. Would battered woman syndrome lie in favor of the wife this time? This time, this defense would not lie in favor of the wife. Insofar as battered woman syndrome is concerned, the law requires that there must be a battery of abuses. And under Section 3B of RA 9262, battery has been defined as the act of inflicting physical harm upon the woman or her children, resulting in physical, psychological, or emotional distress. Therefore, there must be physical harm inflicted on the said woman. And it is necessary, in the case of People versus Marivic Henyosa, Supreme Court said, there must be at least 2 battering episodes. 2 battering episodes of physical harm. And these battering episodes have 3 cycles. There must be the so-called, so-called first we have battery of abuses, then we have tension building, battery of abuses, then we have the so-called tranquil or loving stage. There must be these phases in the so-called 2 battery episodes between the said woman and her partner, her intimate partner. So in this case, there is only 1 battery of abuse because the said woman has been inflicted with physical harm only once. All others were verbal abuses. Therefore, battered woman syndrome would not lie in favor of the said woman this time so as to free her from both criminal and civil liability. She has to be convicted as charged, but of course, there will be mitigating circumstances. Then we go to Article 12. Article 12 punishes Article 12 provides for exempting circumstances. Exempting circumstances are those circumstances which, if present or attendant in the commission of a felony, would serve to exempt the offender from criminal liability because there is the absence of any of the elements of voluntariness. The elements of voluntariness, criminal intent, freedom of action, intelligence. Here, there is the absence of any of these elements of voluntariness, therefore, the offender is exempted from criminal liability. So when any of the exempting circumstances under Article 12 attended the commission of the crime, there is indeed a crime committed, but there is no criminal because he acted without voluntariness. There is no criminal liability, but there is civil liability because a crime has indeed been committed. So that is the effect of an exempting circumstance. There is a crime, but no criminal liability, but since there is a crime, there is civil liability to be imposed on the part of the said accused. And the first exempting circumstance, an imbecile or insane person unless the latter acted during a lucid interval. So based on the first exempting circumstance, we have imbecility, and the other one is insanity. Imbecility is exempting under any and all circumstances. An imbecile is a person who, although advanced in age, has only the mental capacity of a 2 to 7-year-old child. Therefore, when he commits a wrongful act, the law presumes he acted without intelligence. Therefore, there is no voluntariness because intelligence is an element of voluntariness. The same is true in case of insanity. The insanity that is exempting, however, refers to total aberration of the mind. Totally. He cannot determine or appreciate the consequences of his act. Total lack of intelligence, cognition. Insofar as insanity is concerned, before insanity may free the offender from criminal liability, it is necessary that it must be proven that he was insane immediately prior to or at the time of the commission of the crime. This exempting circumstance would not lie in favor of the accused if it is proven that he acted during a lucid interval. So insanity is not under any and all circumstances exempting, because if he acted during a lucid interval, then he incurs criminal liability. Likewise, if the said accused becomes insane during trial, before conviction, after conviction, this will not exempt him from criminal liability. It will free him, in case of conviction, it will free him from serving his sentence. Because instead of being placed behind bars, he will be placed at the mental institution. But it will not exempt him from criminal liability because, again, the insanity that is exempting must be present immediately prior to or at the time of the commission of the crime. In an old case, the Supreme Court said that somnambulism, or being in the state of sleepwalking, is akin to insanity because the offender committed the criminal act unconsciously. So the accused was suffering from the disease of somnambulism. He was experiencing the state of sleepwalking. From a deep sleep, he would wake up. And then thereafter, he went to the kitchen, took a knife. Thereafter, outside, he stabbed the person whom he first passed by. That person died. He was in deep sleep. He was in a state of somnambulism. Supreme Court said it is akin to insanity. It would free the offender from criminal liability. Of course, not from civil liability because a crime is indeed being committed. The second and the third exempting circumstances refer to minority. Insofar as minority as an exempting circumstance is concerned, we go to RA 9344, or the Juvenile Justice and Welfare Act. Under RA 9344, Section 6, if the child is 15 years of age or under at the time of the commission of the crime, he is totally exempted from criminal liability. But if the said child in conflict with the law is over 15 but below 18 years of age at the time of the commission of the crime, if he acted without discernment, he is still totally exempted from criminal liability. But if he acted with discernment, he shall be prosecuted before the courts. So if based on the facts of the problem given in the bar, the accused or the offender is 15 years old or under, you no longer have to look. Based on the facts, you no longer have to determine if he acted with discernment or not. Because just by the mere age of 15 or below 15, he is already exempted from criminal liability regardless of discernment. But if based on the facts, the offender or the child in conflict with the law is over 15 but below 18, you have to further read. Did he act with discernment or not? If he acted without discernment, he is still exempted from criminal liability. If he acted with discernment, then he shall be prosecuted in court. What if the offender is 17 years of age and this offender committed the crime of homicide, and he acted with discernment? He could appreciate the consequences of his act. He knew that killing a person is a criminal act. He acted with discernment, and so although he was a minor, 17 years old, he was prosecuted in court. After trial on the merits, the judge found him guilty beyond reasonable doubt. Will there be a pronouncement as to his guilt? There shall be no pronouncement as to his guilt. There shall only be a pronouncement of the civil liability arising from and based solely on the crime committed. Instead of pronouncing his guilt, he shall be given a suspended sentence without need of application. And under Section 38, this suspended sentence shall be given to him even if he is already an adult at the time of the promulgation of judgment, even if he is already 18 or above 18 at the time of the promulgation of judgment, for as long as he was a minor at the time of the commission of the crime, he is entitled to a suspended sentence without need of application on the part of the defense. It is motu proprio on the part of the judge to place him, to give him a suspended sentence as he was a minor at the time of the commission of the crime, provided under Article 20, he is not yet beyond 21 years old. So the limit for a suspended sentence is 21 years old. The moment this minor offender, this child in conflict with the law, at the time of the promulgation of judgment is already beyond 21 years old, the judge can no longer give him the benefit of a suspended sentence. What if the crime committed by the said minor, 17 years old, was a heinous crime? So the crime he committed is rape, the crime he committed is murder, and he acted with discernment, and so he was prosecuted in court. After trial on the merits, he was found guilty. Is he also entitled to a suspended sentence? He is also entitled to a suspended sentence. In the case of People versus GARCIA, in the case of People versus Mantalapa, the Supreme Court said that Section 38 of RA 9344, as to the giving of a suspended sentence, does not distinguish as to the nature of the crime committed by the child in conflict with the law. Whether the crime committed by the child in conflict with the law is a heinous crime, punishable by capital punishment, or a crime of lesser penalty, he is entitled to a suspended sentence provided he is not yet beyond 21 years old at the time of the promulgation of judgment. So the accused was a minor, and the accused was charged with illegal sale of dangerous drugs. Illegal sale of dangerous drugs is a heinous crime, and it is punishable by life imprisonment to death. And the said accused was 17 years old at the time of the commission of the crime. So he was a minor. And based on the investigation, he acted with discernment. And so, after trial on the merits, he was already beyond. After trial, he was already beyond 21 years old at the time of the promulgation of judgment. And so the judge convicted him. And he appealed. He appealed to the CA. CA affirmed the conviction. He appealed further to the Supreme Court. Supreme Court affirmed the conviction. The issues are, can he be given at the time that he committed this crime of murder, crime of rape, a heinous crime? RA 9344 is not yet into effect. Can this be given retroactive application to him? It can be given retroactive application to him as provided for under Section 68. It is the law itself that provides that this law shall be given retroactive application to minor offenders, those who are minors at the time of the commission of the crime, even if they have been convicted or are already serving sentence at the time of the effectivity of the said law. Can this accused be given a suspended sentence? Although the Supreme Court said, although he is entitled to suspended sentence, regardless of the fact that the crime he committed is a heinous crime, he cannot be given a suspended sentence because he is already above 21. So in that case, what benefit under RA 9344 may be given to this child in conflict with the law? What for is the retroactive application if he will not be given any benefit? Supreme Court said, the only benefit is Section 51. Section 51, which provides that instead of serving his sentence in regular penal institution, this child in conflict with the law shall serve his sentence in agricultural camps and other facilities established by the Bureau of Corrections in coordination with the DSWD. And in the case of People versus Gambao, the Supreme Court said that this would apply even if the said child in conflict with the law is no longer a minor at the time of the promulgation of judgment. So for as long as he was a minor at the time of the commission of the crime, even if he is already an adult at the time of the promulgation of judgment, he need not serve his sentence in regular penal institution. He should be serving it in facilities established by the Bucor in coordination with the DSWD. The fourth exempting circumstance under Article 12, any person who, while performing a lawful act with due care, causes an injury to another without fault or intent of causing it. The elements of this exempting circumstance are: first, it is necessary that the offender was performing a lawful act. Second, he was performing the lawful act with due care. Third, he causes an injury to another by mere accident. And lastly, he has no fault, he has no intent in doing the said injury. The second element requires that the said offender must be performing the lawful act with due care. The due care element in this fourth exempting circumstance is very important because even if the offender was performing a lawful act, if he is not doing it with due care, he becomes liable for a culpable felony, reckless imprudence, or simple imprudence, or simple negligence. So it is necessary that in performing the lawful act, he is doing it with due care, and despite the said due care on his part, he still caused an accident. He still caused an injury on another person without fault, without intent of causing it. In case of exempting circumstances, as I said earlier, there is no criminal liability, but there is civil liability because a crime has indeed been committed. Exception to that is accident under Paragraph 4. In case of accident, there is both no criminal liability and no civil liability. So it is more akin to a justifying circumstance than an exempting circumstance. There is both no criminal and civil liability. Reason is, the offender was performing a lawful act with due care. It was New Year's Eve. Everybody was so happy celebrating the New Year, celebrating the coming of the New Year. There were people in the neighborhood gathered around the street. There were firecrackers, and children were outside making noise to celebrate the coming of the New Year. One of the people in the neighborhood was Police Officer X. At exactly 12 o'clock in celebration of the New Year, Police Officer X fired several shots in the air to celebrate the New Year. One of the said stray bullets hit a child who was on the street watching, enjoying, celebrating the New Year. The said bullet hit the head of the child. The child was brought to the hospital. She went into coma for a period of 2 days. Thereafter, the said child died. And many people saw that in the area, it was only this police officer who fired the shots, who fired the gun, who fired the gun. And so, he was arrested. And he was charged for reckless impudence resulting in homicide. His defense was that it was purely an accident. Will his defense lie in his favor? First element of the exempting circumstance of accident, the offender was performing a lawful act. Was the offender performing a lawful act? He was not performing a lawful act. It has long been prohibited to fire shots in the air, even during Christmas Eve, during New Year's Eve. It is an unlawful act because any stray bullet would hit any innocent person. The first element immediately absent, therefore accident would not lie in favor of the said offender, police officer, in order to exempt him from criminal liability. If you were the judge, would you hold him liable for reckless imprudence resulting in homicide? If that is the charge, of course, if that is alleged in the information. But if the question is, what crime has been committed? The crime committed is not reckless imprudence resulting in homicide. The crime committed is homicide, not reckless imprudence resulting in homicide. Why is the crime committed homicide? The crime committed is homicide under the proximate cause doctrine. When he fired a gun in the air, he was performing a felonious act. It resulted to a felony. And without this felonious act, the said child would not die. Therefore, it should not be merely reckless imprudence resulting in homicide. It should be homicide itself under the proximate cause doctrine. The fifth exempting circumstance, any person who acts under the compulsion of an irresistible force. The exempting circumstance of having acted under the compulsion of an irresistible force, the elements are first, it is necessary that there must be a physical force. The physical force must be irresistible. And lastly, the physical force must come from a third person. Here, the moment the accused was charged for having committed a crime, but he proved that he acted under the compulsion of an irresistible force, he is exempted from criminal liability because he acted without freedom of action, an element of voluntariness. There is no freedom of action because he performed the said act because of the compulsion of an irresistible force. The irresistible force employed by a third person on the accused is said to be irresistible when it has reduced the said accused to a mere instrument such that he acted not only without will but also against his will. He has no other recourse but to obey because of the physical force employed on him. The same is true in the sixth exempting circumstance. Any person who acts under the impulse of an uncontrollable fear of equal or greater injury. The elements of the sixth exempting circumstance are first, that there exists an uncontrollable fear. Second, the fear must be real or at least imminent. And third, the fear of the injury must be greater than or at least equal to the act committed. The first element requires there must be an uncontrollable fear. The fear employed by the third person on the said accused is said to be uncontrollable when it has reduced him again to a mere instrument such that he acted not only without will but against his will. Totally, he has no freedom of choice. The moment he still has the freedom to choose, should I proceed? Should I not proceed? even if there was force employed, even if there was fear in him, this exempting circumstance would not lie in his favor, because there is still the element of freedom of action. It must be totally absent. So totally, there must be no freedom of choice. It is also required, based on the second element, that this fear must be real, or at least imminent. It must not be speculative. It must not be imagined. It must not be in the future. And lastly, this fear of injury must be greater than, or at least equal to, the act committed. So both having acted under the compulsion of an irresistible force and having acted based on the impulse of an uncontrollable fear of equal or greater injury, these are both based on lack of freedom of action and element of voluntariness on the part of the accused. So the woman went to the doctor, and the woman told the doctor to perform an abortion on her. According to the woman, she is 4 months pregnant, and this fetus inside her womb, this baby inside her womb, must be removed. She cannot tell her parents, and so she's asking the doctor to perform the abortion. She heard this doctor performs abortion, but the doctor said, no, I cannot perform the abortion. I would not perform the abortion. And so what the woman did, the woman opened his bag and took out a bottle of poison and threatened the doctor. If you will not perform the abortion right now, I'm going to drink this poison and I'm going to die right in front of you. Afraid, the doctor performed the abortion. Later, the doctor was charged with intentional abortion. The defense of the doctor, he acted under the impulse of an uncontrollable fear of equal or greater injury. Are all the elements of this exempting circumstance present? First, there must be uncontrollable fear. Was there uncontrollable fear? The woman said she would commit suicide, drink the poison, if the doctor will not perform the abortion. She would die right in front of the doctor. That is sufficient to cause fear on the doctor. Second element, was the fear real or at least imminent? The second element is absent. It is not real. It is not at least impending, or it is not at least imminent or impending to happen. Even if she held the poison by her hand, before the doctor can perform the operation, the doctor could have already grabbed the poison, because there were many things to be done before the said abortion. Therefore, the said fear being stated by the doctor is purely imagined, speculative in the future, not impending to happen. The second element being absent, this exempting circumstance would not lie in favor of the said doctor. He shall be held criminally liable as charged for the crime of intentional abortion. There was this bank robbery. 5 men entered the bank, fired at the guards. They entered the bank and told the depositors therein, the clients therein, and all the employees therein to lie on the floor. Afraid, these men were armed with long firearms. They did as instructed. They lied on the floor. And then the head of these robbers, A, asked the manager to open the vault. But the manager would not want to open the vault. And so what A did, he took one of the employees of the bank, placed it in front of the said manager, and told the manager, if you are not going to open the vault, I will shoot your employee. The manager didn't believe it. And so A shot the employee, and the employee died in front of the bank manager. And then A pointed the gun at the said bank manager and told him, if you will not open the vault, you will be the next. Afraid, the said bank manager opened the vault, and the said 5 robbers were able to take away all the money inside the said vault. They were later arrested, and the bank manager was also arrested and charged together. The bank manager was charged as a principal by indispensable cooperation because were it not for his act of opening the vault, the said robbery would not have been consummated. His act is indispensable. However, the manager as a defense invoked the exempting circumstance that he acted under the compulsion of an irresistible force. He acted under the impulse of an uncontrollable fear of equal or greater injury. Would this exempting circumstance lie in favor of the bank manager and free him from criminal liability? First, there was physical force. The physical force came from A. A killed the employee. The said physical force was irresistible, and it comes from a third person. Therefore, it is present. Having acted under the impulse of an uncontrollable fear, was there uncontrollable fear? There was, the first element. The said manager saw A shot the said employee in front of him. It suffices to bring him that fear. Second, was the fear real or at least imminent? Yes. If A had shot the said employee, definitely A could also shoot the said bank manager. Second element present. Third element, the fear of the injury is greater than or at least equal to the act committed. The fear of the manager that he would be next to be shot, next to be killed, is greater than this money in the bank. Therefore, all the elements are present. This exempting circumstance would free him from criminal liability. So this exempting circumstance would lie in his favor. The last exempting circumstance under Article 12, any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. This is another exception to the rule that, in case of exempting circumstances, there is no criminal liability but there is civil liability. In this last exempting circumstance, there is both no criminal liability and no civil liability. This is an act of omission. The accused failed to perform an act required by law. But what is the reason? Because of a lawful, insuperable cause. Since his reason is a lawful or insuperable cause, he incurs both no criminal and no civil liability. So how would you distinguish justifying circumstances versus exempting circumstances? The following are the distinctions between justifying and exempting circumstances. First, in justifying circumstances, the offender is said to have acted within the bounds of the law. He is said not to have transgressed the law, whereas in exempting circumstances, the offender indeed committed a criminal act. Second, in case of justifying circumstances, there is no crime and there is no criminal. Whereas, in case of exempting circumstances, there is a crime, but there is no criminal because he acted without voluntariness. Third distinction, in case of justifying circumstances, there is no criminal liability and as a rule, no civil liability. Whereas, in case of exempting circumstances, there is no criminal liability but as a rule, there is civil liability because a crime has indeed been committed. And lastly, justifying circumstances may be invoked as a defense only in intentional felonies, whereas exempting circumstances may be invoked as a defense both in intentional and culpable felonies. So those are the distinctions: justifying circumstances versus exempting circumstances. Article 13, we go to mitigating circumstances.